Masechet Ketubot Daf Ayin Tet. We're dealing with this partnership of sorts between a husband and wife, where a wife inherits or otherwise brings in land, property into the marriage, and so during the marriage, if they are designated as nichse melog, that would mean that she keeps the title to the property, but the husband gets to enjoy the income from that property. So we'll see some various cases. We start off with a certain woman who wants to hide her assets from her husband. Hahi iteta debaya de tabrechinhu lenichsa migabra ketabtinhu librata insiba v'igarsha. This woman wanted to distance her property from her husband so that she was about to get married and she had some property and she did not want her husband to have access to its income. And so she wrote a document gifting it to her daughter. And that way it's under her daughter's her property, and therefore her husband will not have any access to it. She had a daughter from a previous marriage. This woman then married, and so during the marriage, the husband did not get the profits from it, and in the end, this woman got divorced. And now that she got divorced, she's single, she wants to get her land back from her daughter. Is she allowed to do that? Atay lekamed Rav Nachman, she comes to Rav Nachman. Keda'eh Rav Nachman lishtara. Rav Nachman tore up the document of transfer, the gift document to her daughter, meaning, yes, she can get it back. It was obvious to Rav Nachman that this was not a real gift, but rather a ruse to keep it out of the hands of her husband. Like sometimes today in divorce cases or in bankruptcy cases, people will transfer their money, their property to other relatives to shield them from being collected. So this is an early precedent for that practice. I'm not sure if it's legal today, but it was legal in Talmudic times. Azal Rav Anan lekame de mor ukva amar le hazi mor Nachman chakla'a kechi mekara shetared inashe. And eventually Rav Anan went to Mor Ukva, and Mor Ukva and told him about this case. Mor Ukva says, "Oh, look at this! How this master Nachman, he calls him like by his first name. Mor Ukva, remember, was the exilarch, so he was the important figure. He was the governor of the Jewish community in Bavel, and so he speaks disparagingly of Rav Nachman, this farmer, meaning this simple person, suggesting he's not so learned. Look how he just tears up people's documents. How do you do that? How do you go take a legitimate document and tear it up? So Mor Ukva was against Rav Nachman ruling. He felt once you give it as a gift to the daughter can come and say, she gave it, my mother gave it to me, it's mine, she can't take it back. Amar le emali easy gufa deubada hechi hava. But Mor Ukva nevertheless asked, tell me about the case, exactly what happened. And so Amar le hachi v'hachi hava. Rav Anan told him, this is exactly what happened. She was getting married and she got divorced and so on. Amar le shetar mabrachat kamart. Oh, I didn't realize the background of the story. You're talking about a document of evasion. He didn't realize that she wrote this document only before she got married in order to hide her assets. So now that he said that, Hachi amar Rav Hanilai bar Idi amar Shemuel, More hora'a ani, im yavo shetar mabrachat liyadai, ak ekra'enu. So in fact, Mor Ukva says, I agree in that case, and he quotes Shemuel, who says, I am a authority on halachic rulings, which he was, and he says, if this type of document comes to me, I will tear it up. In other words, it is valid during the marriage to hide the wife's assets so that the husband can't enjoy the fruits. And once the wife is done and wants to get her land back, once her marriage ends, then Shmuel says you can tear it up. And this is a legal loophole, and it is just that, a loophole. She deserves to get her land back. We'll discuss in a second why that works. Amar le Rava le Rav Nachman, Tama mai de la shabik inish nafsheh v'yaheb la'acharine. So Rava is asking Rav Nachman, who is the original one that tore up the document, right? What is the reason for your action? How come you tear up the document? I know why. Because you assume a person is not going to leave his own interests and give it to someone else. A person is not going to give away all this property and be left with nothing. And so that's how we know that if a person gives away all his property, it must mean that they're only trying to hide their assets, but they don't really want to give it away. But here's the thing, Rava says, we can only assume that that would be true if I give it away to someone else who's not related to me. No one would take all of his assets and give it to an unrelated person. So if he does that, it's obvious that this is only an evasion. But to one's own daughter, maybe he does. People often give their property, give a large portion of their estate to their children, even while they're alive. And so a person may very well do that. Therefore, maybe it was a real gift and not just an evasion. But we answer, even a person in relation to his own daughter, nevertheless, is going to prefer himself. No one wants to leave themselves completely with nothing, and so a person still would not. You might give some gift to one's children, but you're not going to give the majority of your land to your own children and leave yourself with nothing. And so, in fact, yes, we know it was only as an evasion, and therefore the gift can be returned. Okay, a challenge to Shemuel's statement and Rav Nachman, who used this. If a woman wants to hide her property from her husband, what should she do? She should write a document of persuasion, lefayes, to others, meaning she's going to persuade a relative or a friend to sign this document saying, I am receiving this property, even though they know it's a fake, so that the friend will not actually come and live in it and acquire it and sell it or anything like that. You get someone who you can trust that will write this for you and help you out, and that way eventually you can get it back. When the marriage is over, the wife will be able to get it back. This is the minority opinion of Rabban Shimon ben Gamliel, who says this works. So this opinion would agree with Shemuel and Rav Nachman, but the Braita says there's a majority opinion otherwise. Chachamim omrim, rasa mesachek ba ad shetichtob lo mehayom velich she'erse. So Chachamim say, if the receiver of this gift, the one who signs the shtar pasim, can deceive her and keep the possession, keep the property in his possession. He can say, you gave it to me as a gift, and therefore I'm keeping it. And so if you want that not to happen, then you have to write in that document, the wife has to write, I am giving you this gift from today until I decide I want it back. So it's a gift with strings attached, and so the wife can always go and get it back. Otherwise, if you don't write that phrase, then the one you gave it to can go and take it back. Apparently, there are some people who try to evade taxes by not putting their income in their own name, but leaving it in an escrow account of a lawyer. So it's never on their own name. They don't have to pay taxes. But there was a case where a lot of people were doing that and giving it to one lawyer, and the lawyer ran away with everyone's money. And so, this is a problem. You want to try to evade the husband, but it could end up backfiring on her if the person that you gifted to actually goes and keeps it. Okay, so according to Chachamim, it doesn't work unless you write this phrase. Ta'ama dechatba lehachi, halo chatba lehachi, kananhi lokeach. Okay, the only reason why this works is because you have to write this phrase. But if you didn't write the phrase, then the purchaser or the person you gifted it to actually acquires it and it's totally theirs and you can't get it back. So we see a contradiction. Shemuel said this kind of gift works, and Chachamim say, no, it doesn't work unless you write this phrase. So which one is it? How could Shemuel go against a Braita and follow just a minority opinion? Amar Rabbi Zera la kashya ha bechula ha bemiksata. So Rabbi Zera says, no, they're not contradicting each other. Rather, the ruling of Shemuel that says it works. If you gift it or do some kind of fake sale, then the wife can always get it back. That's when she gives away all of her property, because it's obvious no one would give away all of their property in their lifetime, leave themselves with nothing. So then it's obvious that this was a loophole and not a real gift, and so she can get it back. But if it's only part of the property, sometimes people do give a gift of part of their property, certainly to their children, maybe to a friend as well. And so in that case, that's where the Chachamim of this Baraita we're talking about, where you have to write in that phrase, because it wouldn't be so clear to an onlooker that the person does not mean it as a full gift. Okay, ve'ila kanan hi lokeach niknin hu baal. And so now we go back to the this whole mechanism. How does this whole mechanism work? Because after all, if the buyer does not actually acquire it, and the bride and the wife can take it back at any time, then really it does in fact belong to the woman, because the buyer, it's a fake sale. And if it does belong to the wife, then the husband will have in fact access to it and should be able to enjoy the income from it. It says here to acquire it, not that the husband will take it and keep it. The husband can't keep it forever, but he can take it and use it for the duration of the marriage. So in other words, you get one or the other. Either it's a real sale gift to that relative, and fine, but then the wife can't get it back. Or it's a fake sale, and so the wife can get it back, but if it's a fake sale, then the husband should be able to get the produce. Amanda Baye, Rabbi explains that this whole mechanism, this loophole, is following the opinion of Rabbi Shimon. Was the very end of the previous Mishnah, who said that if there is property that's not known to the husband, then that's off limits. All right, we define that as if it's in a foreign country, and so he doesn't know about it, he doesn't have access to it, then he does not enjoy the income, even though she does own it. And so this would be the same thing, even though it might be here right next door, this property, but because she shielded it by doing this quasi gift or sale to someone else, so that is sufficient to make it that she owns it, but it's not known to the husband, and so he does not have access to its produce. Very good. Next Mishnah. Naflu la kesafim yilakach bahen karka v'hu ochel perot. Until now, we were dealing with a case where the wife inherits or brings in some land. Land is good because you have the principal, the land itself, that remains, so she always has access to that, and it also produces income which the husband can get. What if, however, she inherits or any way that she acquires money, cash? And in that case, well, this is not as convenient, because if the cash all goes to the husband and he just spends it, then she's left with nothing. On the other hand, if they keep the cash in a bank account of some sort, they didn't have banks, so keep it, under their mattress, well, then it's not producing any income, and then he loses out. So we want to have a situation where you can have both. So the Mishnah says you take the money and you should buy land with it, and then once you have the land, so the amount of the money that she's bringing into the marriage, she will be able to take out at the end. That's the value of the land, and during the marriage, he will be able to enjoy the fruit. So this is a good deal. This is a good investment. It will preserve both the principal and allow for income. Same thing, if she brings fruit into the, so not cash, but merchandise or actual fruit into the marriage. So in this case, he doesn't get the fruit because the fruit here is the principal that she's bringing in. In a usual case, she owns the land, the fruit is the income. But here, since she's bringing in fruit, the fruit is the principal. And so if he just takes it all and spends it all, she'll have nothing left. So we treat the fruit like the cash and we buy land with it. She retains the title to the land, and he enjoys whatever the fruit that the land produces. Now, next case is perot mechubarim bakarka. She brings in land with fruit on it that's still attached. So at the time of the marriage, she's bringing in both land, and the fruit is now still there. So what's the status of that produce, that season? The next season, whatever grows, will belong to the husband. But at this point, it's not harvested, and she's bringing it in with the fruit. So what's the status? It's a machloket. Amar Rabbi Meir sheminota kama hi yafa beperot v'chama hi yafa belo perot umotar lakach behen karka v'hu ochel perot. It's going to be Meir because she's bringing it in with the fruit, so that she retains the title to the land and she owns that crop of fruit for that season. So how do you, since she owns it, so how are we going to evaluate it? So here's how you do it. We make an evaluation, an assessment. We bring an assessor in, and we ask, we assess how much is this land worth with the fruit on it, and how much is the land worth without the fruit on it. And so the difference between those belongs to her. That money belongs, the whole land belongs to her, but she'll get the land back at the end. The first produce belongs to her, and so he will take out of his pocket money equal to that amount of the difference, meaning that crop, and with that money, whatever is in between, he will buy land with it, and after that, then he could take that crop and all future crop that land and the land that he buys will produce, he can keep. So that way, the fruit that she's bringing into the marriage that's still attached to the ground, that is part of the principal, and so that will be converted to land and remain with her. Chachamim disagree with Rabbi Meir and say, just like the husband enjoys the produce of the land throughout the marriage, he even enjoys that first crop, even though she brought it in already. So you don't have to do any of this. She just retains the title to that land, and he enjoys even the first crop. Hatelushim min hakarka shela v'lakach behen karka v'hu ochel perot. But Chachamim will agree that any fruit that's detached from the ground, this is the same as the first case above here. This is just like cash that she brings into the marriage. So it is hers, and she wants to preserve the value of it. So therefore, if it's not attached to the ground, then he should buy land with it, and then he can consume the produce of that land. All right. Rabbi Shimon Omer, Makom sheyipa kocho b'nichnisata, hura kocho b'yesiata. Makom sheura kocho b'chnisata, yipa kocho b'yesiata. The Mishnah answers a statement of Rabbi Shimon. Rabbi Shimon seems to be saying the same thing as Chachamim. The Gemara will ask why is he saying the same thing, but he's formulating it in a kind of interesting paradox. So he's noting that any place where a man's right is superior at the beginning of the marriage, then his rights will be inferior at the end of the marriage. And the opposite, any place where the man's rights are inferior when he gets married, they will be he'll have the upper hand, superior, when they divorce at the end of the marriage. Okay, Kesad, how does this apply? Perot mechubarim lakarka bichnisata shelo b'siyata shela. Fruit that is connected to the ground, and so therefore that is, according to Chachamim, it's considered his, right? He gets it, even though it's the first crop that she brings in. Nevertheless, that's still called fruit. That is the income of the land. So therefore, at the beginning of the marriage, it belongs to him. Whereas at the end of the marriage, if they get divorced before the crop is harvested, then she takes back her land with the fruit on it. So fruit connected to the ground, she keeps. So you see his right is inferior at the end. And the opposite for telushin minakarka, if she just brings in regular fruit, not connected to the ground, that's the same as cash. Bechnisata shela, when she brings it in, that is now not the income, but that's the principal. The fruit itself is the principal. So it belongs to her. And therefore, that's why he has to sell it and buy land with it. But at the end of the marriage, he keeps it because if there's just fruit that he got from her land, then at the end of it, he already harvested it. He is able to keep it. So each one has both a benefit for this person and that person. Okay, Pishita. Now we're going to ask about the relative value of the following investments. So some good investment advice. Ad'a ubate ad'a. If you have a choice of buying either land or a house, like let's say one of the spouses, the husband or the wife says, why we should buy land. The other one says a house. Land is a better buy. It's more durable. It will produce. Bate v'dikle bate. If the choice is between houses and palm trees, houses are more durable than palm trees. Dikle v'ilane, palm trees and other types of trees. Other types of palm trees win out. Ilane vigufne ilane, between regular trees and grapevines. Grapevines are very delicate, so the regular trees are better. The first item in each of the pair is always the one that's more durable, and therefore should be the preferable one. The point is that we want to keep the wife's property intact, so that at the end of the marriage, she will be able to take it out with her and use it to sustain herself. Okay, Abba ze radta ufera de chavre. Amri la pera v'amri la karna. Now the following items, we're not sure, should they be considered like land, like a principal, and that she keeps it, or should they be considered like cash or like fruit, in which they should be sold to buy land. So these are items that are going to be consumed and depleted. So if she inherits a forest of these hawthorn trees, this is the hawthorn fruit, which is not usable, and so therefore the fruit is not going to afford anything, but rather it's just the trees themselves that will be cut down for wood. But eventually there won't be any more trees anymore, so this will be depleted. Or fida, this vocalization is a mistake here. Pida is different from pera, not to be confused. Pera means fruit. Pida means a ditch or a pool or pond. Dechavre, of fish. If you have a pond of fish that's not regenerating, it's not connected to a river, and so once you deplete the fish, there will be no more fish. What is the status of that? So some say that the wood and the fish are like produce. In other words, the husband, can keep the forest and the pond and consume the wood and the fish until they are depleted, because the land is still there, the pool is still there. So they are like produce. But others say that the wood and fish themselves are like the principal, and they do not replenish. And so therefore, they are like cash. You would have to take this whole thing, sell it, and buy something that is replenishable, like land. Regarding trees, this is the principle. If the trunk renews itself, and you cut off a piece of it, it'll regrow. Well, then that is produce. He can keep those trees and enjoy the continual cutting off of the branches, because the trunk will renew. But if it's the type of tree that once you cut it, it will not renew, well, then that is the principle itself. The wood is the principle, and therefore he can't just take it all and leave her with nothing. He'd have to sell it and buy something like land. Amar Rabbi Zera, Amar Rabbi Oshaya, Amar Rabbi Yanai. V'amri la Amar Rabbi Abba, Amar Rabbi Oshaya, Amar Rabbi Yanai. So we know this is in the name of Rabbi Oshaya and name of Rabbi Yanai, but the direct person who said it is either Rabbi Zera or Rabbi Abba. However, it is said, Hagonev velad behemat milog meshalem tashlome kefel laisha. Okay, just like I could have land that's milog, so too you can have an animal that's milog, meaning she keeps the title to the animal. But anything the animal produces will belong to the husband, meaning the husband can take the animal and milk it or use it to work the land. But what about offspring of the animal? Do we consider the offspring of the animal to be an increase in the principal and so belongs to her? Or is that something that the animal produces in income and therefore belongs to him? Well, these rabbis said that if someone comes and steals the offspring of the animal, then the thief has to pay double back to the wife, which would mean it belongs to her. So that means the offspring belonged to her. So the offspring is considered part of the principle. That's what these sages rule. We ask, Keman, who does this follow? Lo k'Rabbanan velo k'Chananya. Apparently, not like the rabbis and not like Chananya in the following Baraita D'Tanya. Velad behemat melog la Baal, velad shivcha melog la Isha. Chachamim say that the child of an animal, this type of animal where she keeps the title to it, goes to the husband. Unlike the child of a maidservant where the wife keeps that child. Whereas Chananya ben Achi Yoshiyahu Amar Asu Velad Shivchat Melog Kivlad Behemat Melog. He says they are both the same, and the child of the maidservant is the same, has the same status as the child of the animal, and both go to the husband. Okay, so now there is a machloket regarding the child of a maidservant, but both agree that the offspring of an animal goes to the husband, and therefore in this case, when this animal had a child and was stolen, the thief should pay back the husband because he owned the offspring and not the wife. So who are they following? It's like neither opinion in this baraita. And we answer, Afilu tema dibra kol. In fact, these sages, right? Remember, and this is all in the name of Rabbi Yanai. Rabbi Yanai can follow all of the sages in this baraita. Why? Pera takinu le Rabbanan. Pera de pera lo takinu le Rabbanan. The rabbi said that a husband can enjoy the produce of land or an animal, yes, but produce of produce, no. So it's true that the offspring of the animal will belong to the husband. But when it's stolen and he's paying back, so that double payment is a kind of income that one is getting from the offspring itself. So yes, the husband gets the direct offspring, but the grandchildren, so to speak, of the animal, that's the animal's offspring, and now payment for that offspring is further a next level step of income that is being made from the offspring. So that goes back to the wife. Okay, so that explains it. Okay, now we want to understand what is the logic of each of these opinions in the Braita. According to Hananya, who says it's the same. A maidservant and animal are the same. They both go to the husband. The reason is because we don't worry about death. That's nice not to worry about death at all. But here we're talking specifically about the death of the mother animal or the maidservant. And therefore we assume that this animal, this maidservant, will be around at the end of the marriage, and the wife will be able to retrieve it. So since she has a principle that will remain alive, therefore the offspring, the child, can go to the husband. But according to Rabbanan, why would he make a distinction between humans and animals if he worries about death, meaning eventually this animal, this maidservant, is going to die, and he worries and assumes that it very well may die before the end of the marriage. In that case, regarding the maidservant or the animal, he should agree that the child of the animal should not go to the husband, because if the husband gets the child and the mother dies, that will leave the wife with nothing. So then that should be true for both cases. And if he's not worrying about death, like Hananya, and we assume that the mother will remain alive and the husband, the wife will get it back, well then, regarding the maidservant, he should agree that we don't worry about death, and therefore the child of the maidservant can go to the husband. Which one is it? Either you worry about both the human and animal, or worry about neither. And the answer is leolam chayshe lemita. He does in fact worry about death. V'shani behema diika ora. But he does worry about death. That's why in the case of the maidservant, he's going to get the wife will get the child. But in the case of an animal, even if the animal dies, there is still a lot of value in its hide. And so the wife will still keep that hide, keep the value of that hide, and take it with her at the end of the marriage. So it won't be a total loss for her. She does keep the principal. So alive or dead, she gets that animal, and it's worth something, whereas a maidservant who's alive is worth something. A maidservant who's not alive is not worth anything. Amar Rav Huna bar Chiya Amar Shemuel halacha ke Hananya. So Shemuel says we follow the law like Hananya, that there's no difference between the maidservant or the animal, they both belong to the husband. Amar Rava Amar Rav Nachman af agav damar Shemuel halacha ke Hananya modeh Hananya shim nitkaresha notenet damim v'not tartan mipnei shevach bet aviha. So even though we follow Hananya, and the children of the maidservants, therefore, will go to the husband, but he agrees that once they divorce, she can give money, pay the husband for those children, and keep them because of the benefit of her paternal family. In other words, she brought into the marriage this maidservant from her family, and they want to keep this lineage in their family. So even though she does not have a right to the child itself, but she kind of has first right to buy it, to buy the child, so that they can keep that family of servants in their estate, in her father's estate. Amar Rava Amar Rav Nachman הכניסה לו עץ לעז לחלבה ורחל לגזעתה תרנגולת לבשתה ודקל לפירותיו אוכל והולך עד שתכלה הקרן. If she brings into the marriage a goat, and it will produce milk during the marriage, or sheep, it will produce wool shearings, or a hen that will produce eggs, or a palm tree that will produce fruits. So the law is the husband can eat benefit from the fruits, from the milk, from the shearings, from the eggs, from the dates, until the principle dries up. If it's a goat, eventually it'll dry up and stop giving milk, but that's okay. So the principle remains in existence, so she keeps the principle. And even though these are items these are all principle, unlike land that will continue producing forever, these have a limited duration, but nevertheless that is their produce. Amar Rav Nachman, Ayla leil gilima, perahave mechase be ve'azil ad de chalya. Rav Nachman said the same would be true regarding a cloak that she brings in. So she retains the title to the cloak, but the usage of the cloak, meaning the benefit of wearing it, that is its produce, that's its income. And so therefore the husband, can use it and cover himself with it until it's worn out. And then the worn out garment, that's the principle that remains, and she can keep that. What good is a worn out garment? We saw before, use it in the summertime when you want a thinner garment. Okay, Keman, now who does this opinion follow? Kihaitana, de Tanya. In other words, we're talking about something that eventually dries up, like these animals, or like this cloak, that it can still be considered principle. Whose opinion is that? It's the following Tana. De Tanya. Hamelach ve'achol hareze perot. If she brings into the marriage some location of sand, salt or sand, there's some area on the shore where salt water is constantly coming in, and so the salt deposits in that area, on that beach, or sand that continually deposits on the beach, and so you can go and collect salt or sand from there. So this is replenishable. So certainly that area is the principle, and the salt and the sand are the produce that the husband can continually take. Everyone agrees with that. Here's the machloket is about pir shel gofrit, machporet shel sarif, a quarry of sulfur or of alum. This is what a sulfur deposit looks like. And this, once you take the sulfur, it does not replenish, or the alum that's used for dyes and other things, it does not replenish. So this eventually will be depleted. What is the law? Rabbi Meir Omer Keren. So he says that the sulfur and the alum that you take from it are the principle, and therefore he can't just come and take all of it. There'll be nothing left. Instead, he would have to sell it and buy land. Hachamim omerim perot. Chamim say the sulfur and the alum that you take are the income, are the produce. He can take, even if he takes it all, because in the end there will still be left that area, the area of the mine, of the quarry, that she keeps, even though it's not going to produce anything more. So the Rav Nachman and Rava here can follow the Rav Nachman, right, can follow the opinion of Chachamim, who say you can benefit from something that from the use of something, even though it dries up and no longer produces, as long as there is something left. We can consider the principle. Rabbi Shimon Omer, Makom sheyipa kocha. The statement of Rabbi Shimon that restated what Chachamim say with that paradox form. We ask, Rabbi Shimon, Hainu Tanakama, aren't they the same thing? Rabbi Shimon is the same opinion as the Chachamim there. Amar Rava, mechubarin bishat yetziah ika benaihu. There's a practical difference between them if it was attached at the time of the end of the marriage. The rabbis would say that belongs to him, whereas Rabbi Shimon, it's evident from the language of his paradox, say that would belong to her. And now we get to the last Mishnah. נפלו לעבדים ושפחות זקנים ימכרו וילקח בהם קרקע והוא אוכל פירות. If she brings in and brings into the marriage slaves or maidservants that are elderly, and so they most likely will die soon before the end of the marriage, and then she'll end up with nothing at the end of the marriage. So therefore they should be sold, and you should buy land with them, and he will therefore then enjoy the fruits of the land during the marriage, and then she'll take the land back at the end of the marriage. That's Tanakama. Rabban Shimon ben Gamliel omer lo timkor mipnei she'en shevach bet aviha. He would say no, he cannot force her to sell it, because this is the assets of her family, and they got to know, they're to my human beings. They got to know they're the servants, and therefore he can't just go and sell them because they have an emotional attachment to them. Even though that may mean that they will die, and then she won't be left with them. The same law regarding olive trees or grapevines that are elderly. They have, they last a certain amount of time. Then they're going to die. Also, those should be sold and buy land. And then he will consume the fruit, because if you keep the vines and they die, she will have nothing left. Rabbi Yehuda says the same law as Rabban Shimon ben Gamliel, but applies it to the olive trees and the grapevines, that this also have sentimental value, and they were in the families of her family for a while, so she can say, no, I want to keep them. Amar Rav Kahana Amar Rav. מחלוקת שנפלו בשדה שלה, אבל בשדה שאינה שלה דיברה כל תמכור, משום דקה קליה קרנה. So Rav says, this machloket between the Tanakama and the Rabbi Yehuda is only if those olive trees and grapevines are in her own land, then she can say, I want to keep them, because even if they die, she still will retain the land. But if she owns grapevines on someone else's land, and that would mean once the grapevines die, then she will have nothing. Then everyone would agree that they should be sold. Even Rabbi Yehuda would agree they should be sold because the principle will be gone, and so that will override the concern that there is that they belong to the father's house and sentimental value, anything like that. because then she'll be left with nothing. Matkif la Rav Yosef. Rav Yosef disagrees, challenges the statement of Rav, or this version of it. Look, you have the first half, the argument about servants and maidservants, and that is similar to grapevines on land that's not hers. Just like grapevines on lands that's not hers, once the grapevines die, she will be left with nothing. So too the maids and maidservants, once they die, she will be left with nothing. And yet you still have a machloket, so the machloket should be able to apply in both cases. Ela itmar hachitmar. So rather, let's reformulate to make it make more sense. Amarav kana amarav. This is actually what Rav said. Machloket besadeh she'ena shela. The machloket here is if the grapevines are on land that is not hers, well then it's possible to keep it or sell it. But if the grapevines are on land that does belong to her, then everyone would agree that they should not be sold. Even Tanakama would agree with Rabbi Yehuda that they should not be sold because these are things that she brought in from her father's house, and so they have a value to her father's house. And in the end, even if they die, she'll still have access to the land. So the principle remains. So therefore, they should not be sold. Baruch Adonai Leolam. Amen ve'amen.